Hello, Colorado employers. Hey, listen, we are in a state right now where it is becoming very apparent that if we do not have great cultures, the government is going to continue to regulate. And if we don't have great cultures, our employees are going to start to unionize. And so I want to make you aware today of some of the new laws that have passed over the last couple of months that you need to be aware of and following. And then I really want to encourage you that if you need help and you want to continue to create great cultures, please reach out to us and have just a quick call. We can help give you some pointers and some tips and tricks on what you might do to, continue to create a great environment where people are thriving. And ultimately, you won't have to worry so much about all these regulations. Because I'll tell you this, if you're already doing everything you possibly can to have a great environment, a lot of these rules are just not even going to really matter that much. But so here are some of the big laws that have come out. There's one called family. You should be aware of this one because it's been around for a while. We've been talking about it for a while. It's spelled FAMLI. And basically, you need to have submitted your Q2 2023 wage reports and your pay premiums to avoid penalties. The deadline for this was July 31st of this last year. And with this law, you also need to be, if you're considering a private family plan for 2024, then it's important that you submit an application for the private plan on or before October 31st. So just a little bit around the corner here. There's a list of currently approved private plans in the show notes for this. You can also find them on our website and our blog. Additionally, you do need to know that all employees who take leave in 2023 may also be eligible for leave in 2024. We'll be sending out more information about this, about family here in the fall. And also, there's more information on the family.colorado.gov website. So keep your eyes on that as well. So that's the first law. The second one is paid sick leave changes. So effective August 7 of 2023, Colorado has amended the allowable reasons for use to use the state mandated paid sick leave to now include bereavement time for a family member whose school or place of care was closed due to weather and home evacuations. So the law is much more expanded now on what it means to take paid sick leave. And again, more information on this is on cdle.colorado.gov. Also, there's some new rules around the I-9 forms. That's for proving your status as a citizen or an immigrant. So the U.S. Citizenship and Immigration Services recently announced a new I-9 form, which has been streamlined, which is great, shortened, so that's great, so that employers can begin using it here as of August 1st. Employers may also continue to use the older version through October 31st of this year, but you do need to start using the new form as soon as possible. And again, linked in the show notes, and you can also see it, just do a search on the new I-9 form. It's a federal thing. There's a new law also called PFWA. This is the Pregnant Workers Fairness Act. And so if you have 15 or more employees, then you need to know that there's a new law that went into effect on June 27, called the Pregnant Workers Fairness Act, or PWFA. This is a new federal law that requires covered employees to provide reasonable accommodations, and that's kind of in quotes here, to a worker's known limitations related to pregnancy, childbirth, or other medical conditions, unless the accommodation will cause the employer undue hardship. So for example, if you have an employee who's recently been given birth and they're breastfeeding, you need to be providing them reasonable accommodations for pumping at work, as well as time to do that. So this applies only to accommodations because otherwise there's existing laws that the EEOC already is enforcing that will make it illegal to fire or otherwise discriminate against workers on the basis of pregnancy, childbirth, or other medical conditions. This does not replace federal, state, or other local laws that are more protective of workers affected or experiencing pregnancy, childbirth, or other medical conditions. So this new law is going to be found on the EEOC.gov website. And you can look it up really quickly. They've got a nice title. It's What You Should Know About Pregnant Workers Fairness Act. So separated by hyphens. So, I guess that makes it easier to read. And then the next one is POWR, POWR. So on August 7th of this year, the Protecting Opportunities and Workers' Rights, or POWR, Act went into effect, which significantly transforms Colorado's employment discrimination legal landscape. This also expands the Colorado Anti-Discrimination Act. So basically, in a nutshell, this law is a little bit scary and something to be mindful of. The Power Act changes the standard of harassment claims, as well as it broadens the type of conduct that constitutes harassment. It also sets a much higher standard for employers' policies and programs to address and prevent harassment. Employers need to establish and publicize a program or improve their existing programs to deter harassment and put a system in place to investigate harassment complaints in order to preserve their ability to utilize an affirmative defense. Basically, what it means is that there's a broader definition for what constitutes harassment. And if we don't teach this and help our fellow employees understand this, we're going to get in trouble. And additionally, anytime someone files any kind of a complaint, we need to be documenting it and showing that we're doing something about it. It also sets stringent requirements on non-disclosure provisions that limit the ability of employees to disclose any alleged discriminatory or unfair employment practices, with some limited exceptions. It also adds marital status as a protected category. This new law also requires employers to retain all personnel or employment records for at least 5 years after the latest of the following: the date of the conclusion of any discrimination charge or related action, the date that the employer created or received the record, the date that the personnel action that the record relates to. So this is a pretty intense law. And because of that, we've built out a whole program to help you. So we have all these templates we put together, presentations, everything that you can get from us that will help you. And then if you don't have an HR team to help support you through this, we can also help you actually implement it inside your organization. But this is a pretty big deal. And you can find out more information in the show notes or at leg.colorado.gov. And then you can kind of have to go through that site to then find the actual bill. There's also some poster updates. I think those are kind of easy to follow, and hopefully you've already got someone, berating you with tons of marketing to help you make this happen. If not, it's in the show notes. And that is it, folks. There's a lot of new laws, a lot more coming. And my overarching message is that when you care for your employees and you do right for your employees, none of these things will be something you need to worry about. It's just in the event that you have an environment that's somewhat toxic or has an environment, you've got people who are a little bit not that great to be with, you're going to have issues. And so you either need to nip that in the bud and do something about it, or be prepared to have the law come down on you. We're here to help you. We're here to support you. So please reach out if we can be of any assistance. Thanks so much.